Welcome to today's program, Legal Ethics, The Dirty Dozen, Part 1. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Today's program is a legal ethics program focusing on the Dirty Dozen, by which I mean the 12 dirtiest, most unethical lawyers in the history of lawyering in the United States. These guys are the worst of the worst. Most of them are already infamous household names, and nearly all of them have been disbarred for their conduct. Oddly, these dozen former lawyers fall neatly into three groups: plaintiffs' securities lawyers, politicians, and criminal defense attorneys. In this program, we'll take you through what each of these guys did that got him into hot water, which laws and ethics rules they broke in the process, and give you some insight into how these guys went from legal eagles to legal turkeys. In Part 1, we'll make it through the plaintiff's securities lawyers and start on the politicians. And in Part 2, we'll finish up with the politicians and then turn to the criminal defense lawyers. And you'll find out who is number one on our list of the most unethical lawyers in the history of the United States. Without further ado, let's start with our first category, the plaintiff's securities lawyers. If you're over 40, you'll remember the powerhouse plaintiff securities law firm of Milberg Weiss. These guys were hands down the most successful firm in the history of plaintiff securities litigation. Anytime a public company's stock dropped by more than 10%, lawsuits alleging securities fraud were filed, and these guys always won the race to the courthouse door. Being first to file meant that Milberg Weiss was likely to be appointed lead counsel for the class, and thus likely to receive the lion's share of the legal fees. How exactly were they always able to get there first? More about that later. Before Congress passed the Private Securities Litigation Reform Act in 1995, which was intended to curb the worst abuses of private securities litigation, and for more than a decade thereafter, Milberg Weiss ruled the roost among plaintiff securities law firms, bringing thousands of cases and earning hundreds of millions in fees, primarily from settlements in large securities class action cases. Corporate directors lived in constant fear of Milberg Weiss because a securities lawsuit meant not only millions of dollars to defend the case through the often dozens of depositions and thousands of documents produced in discovery, but at the end of all that, millions more in settlement payments to the class and still millions more in fees to Milberg Weiss. The leaders of Milberg Weiss in those days were Mel Weiss and Bill Larack, numbers 11 and 12 on our list. To cut to the chase, both Weiss and Larack were summarily disbarred in 2008 after each pled guilty to one count of felony conspiracy to obstruct justice and to make material false declarations under oath in violation of Sections 371, 1503, and 1623A of Title 18 of the United States Code. Weiss was sentenced to serve 30 months in prison, to do 1,000 hours of community service, to pay a fine of $250,000, and to forfeit $9.75 million in proceeds from the conspiracy. For his part, Larack was sentenced to serve 24 months in prison, the same 1,000 hours of community service, and $250,000 fine, and $7.75 million in forfeited proceeds. Before his mighty fall, Bill Larack was known as the king of the class actions, and corporate managers who were forced to pay millions to settle cases he brought called it being Laracked. Bill Larack still lives today in a $24 million home in the Tony suburb of La Jolla near San Diego. As part of his required community service, Larac sought permission to teach a class at the UC Irvine School of Law, but the judge in his case denied the request. Here's what the judge, the Honorable John Walter of the U.S. District Court in Los Angeles, said in denying Larac's request to teach. Quote, "He still denies that he did anything wrong. He misled and fooled the court into believing he had remorse at the time of his sentencing." End quote. The judge added that he now believes that his original 24-month prison sentence was, quote, "way too lenient," end quote, and that he should not have accepted Larac's plea deal. In fact, in Larac's motion to the court seeking credit toward his court-ordered community service for teaching the proposed course, Larac said that he would, quote, "caution students to practice law ethically and within the strictures of the law, and he would counsel them on steps they might take to avoid his fate," end quote. Judge Walter said that the only message Larac could teach students was, quote, "don't get caught," end quote. Ouch. I don't think we'll see Bill Larac molding and shaping young legal minds anytime soon. How is it that after pleading guilty to a felony, Bill Larac still could believe he did nothing wrong? In his mind, he apparently thinks that Wall Street is evil and that every public company is in the process of committing fraud on their shareholders each and every day. So in Bill Larac's mind, if he had to commit a little fraud himself in order to fight this larger corporate fraud, that was a price he was willing to pay. But unlike some other crusaders against corporate greed, Larac got really, really rich from his fraud, and he still has most of that money, even after having had to disgorge some of the proceeds. Before I got into entertainment, I used to practice securities litigation on the defense side, and we would frequently be opposing counsel in cases where Milberg Weiss appeared for the plaintiffs. I can tell you from my own experience that for every Enron or WorldCom, cases where there was actual fraud by corporate managers that resulted in massive losses to shareholders, there were 100 cases where the company did nothing wrong and Milberg Weiss filed securities fraud cases seeking to recover money anyway, and of course, to earn their fat fees. And negotiating settlements with these guys was such a disgusting and repulsive process that you had to take a shower afterwards. More about that later. So what exactly did Weiss and Larac do, and why was it criminal? Remember what I said earlier about Milberg Weiss always winning the race to the courthouse, which put them first in line to collect big fees when the case settles. It turns out that they were cheating and paying people off to prevent their cheating from being exposed. Specifically, they had agreements with a handful of individuals to serve as named plaintiffs in their many cases to pay them, either directly or indirectly through bogus referral fees or professional fees paid to co-counsel, who in turn paid them to the plaintiffs for their service. These individuals owned one share of stock in practically every public company, which gave them standing to sue in nearly every securities case that Milberg Weiss wanted to file. Paying the named plaintiffs something extra created a conflict of interest between the paid plaintiffs and the rest of the plaintiffs in the settlement class that, if disclosed, would have prevented Milberg Weiss's clients from serving as named plaintiffs. Because Milberg Weiss represented the named plaintiffs and needed those plaintiffs to be confirmed as the class representatives in order for Milberg Weiss to be named lead counsel, Milberg Weiss needed to keep their payments a secret. The problem is that named plaintiffs in securities class actions need to file declarations and sit for depositions, wherein they must provide testimony under oath about their qualifications to serve as lead plaintiffs. If they answered truthfully, the improper payments from Milberg Weiss would have come to light, thus disqualifying them from serving as class representatives and Milberg Weiss from serving as class counsel. To prevent this, Weiss, Larac, and other Milberg Weiss partners conspired to make and cause to be made false and/or misleading statements in documents filed in these class actions and in sworn testimony. In pleading guilty to felony conspiracy to obstruct justice and to make material false declarations under oath, Weiss and Larac admitted that they knowingly procured this false testimony and false court filings, and in doing so had obstructed justice. That is how both of them became convicted felons. Here's a quick quiz to see how much you remember from law school. Does a lawyer's conviction of a felony under federal law result in that lawyer's automatic disbarment under state law? The answer, somewhat surprisingly, is no. Each state has its own standard for determining when a federal felony conviction is grounds for disbarment and whether that disbarment is automatic or discretionary. Let's start with California, where LARAC was admitted. Business and Professions Code 6102 requires suspension of an attorney upon conviction of a felony, either under California law or federal law, or upon conviction of any lesser crime involving moral turpitude. The suspended attorney would then be entitled to a hearing on whether he should be disbarred. However, if the conviction is for a felony, and if an element of the offense is the specific intent to deceive, defraud, steal, or make or suborn a false statement, or involve moral turpitude, the California Supreme Court shall summarily disbar the attorney. In LARAC's case, summary disbarment was warranted because he was convicted of a felony, and that felony involved moral turpitude per se, as it was a conspiracy to obstruct justice and to make false declarations under oath. Indeed, while LARAC was served with an order to show cause why he should not be disbarred, he failed to respond, presumably because he knew summary disbarment was required by Business and Professions Code 6102 and the relevant case law. Although it was conceded in LARAC's case, determining precisely which felonies involve moral turpitude is not easy because moral turpitude, as the California Supreme Court recognized in 1972 in re Higbee, is an elusive concept incapable of precise general definition. As the court noted in re Craig, one dramatic exposition of the term was rendered by this court in 1938 and has since been consistently followed: an act of baseness, vileness, or depravity in the practice and social duties which a man owes to his fellow men, or to society in general, contrary to the accepted and customary rule of right and duty between man and man. Moral turpitude also has been described as any crime or misconduct committed without excuse, or as any dishonest or immoral act not necessarily a crime. It has also been vaguely defined as everything done contrary to justice, honesty, modesty, or good morals. Finally, as the California Supreme Court most recently opined in People v. Castro, in which it came perilously close to stating the obvious, in short, there is no hard and fast rule as to what constitutes moral turpitude. In other words, the California Supreme Court knows moral turpitude when they see it, but there is no way in hell they can tell you exactly what it is. For Mel Weiss, who was disbarred in New York, that standard is easier to follow, albeit still somewhat odd. In New York, conviction of a federal felony does not trigger automatic disbarment unless the offense would also constitute a felony under New York law. See the Court of Appeals decision in matter of Margiotta and the Appellate Division's decision in matter of Sorin. With all apologies to the great state of New York, isn't it a bit self-important to say that a federal felony isn't good enough unless it's also a New York felony? In any case, because of this requirement, the justices of the Appellate Division who decided Weiss's case had to go through the exercise of determining that felony conspiracy to obstruct justice and to make material false declarations under oath under federal law was also a felony under New York law, which they of course did, to wit, enterprise corruption in violation of New York Penal Law Section 46020, and offering a false instrument for filing in the first degree in violation of Section 17535. Once that standard was met, Weiss was automatically disbarred. No showing of moral turpitude was required, although if it were required, I'm sure the justices wouldn't have had any trouble finding it, whatever it is. Like LARAC, Weiss didn't bother to appear in his disbarment proceeding. He probably knew that the writing was on the wall. Before we leave Weiss, LARAC, and Milberg Weiss, it's important to note that putting Weiss and LARAC behind bars didn't put an end to abuse in plaintiff securities litigation. In fact, one shady practice that Weiss and LARAC pioneered, so-called disclosure settlements in merger cases, is still alive and well today, although some judges in Delaware have recently begun to crack down on it. As bad as paying off named plaintiffs in class action cases was, filing lawsuits threatening to block corporate mergers in order to extort money from the parties is arguably just as bad, although because the practice is not illegal, their conduct wasn't criminal, but it certainly wasn't ethical either. Now, let's turn to number 10 on our list of the 12 most unethical lawyers in U.S. history, Rod R. Blagojevich. What did Rod do that was so bad it was criminal? He tried to sell a seat in the U.S. Senate for cash, or at least a job that would pay him cash, or at least a job in President Obama's cabinet. You may recall that in 2008, Senator Barack Obama of Illinois had just been elected President Obama, and as the then governor of Illinois, Rod had the right to appoint a replacement to serve out the rest of Mr. Obama's term. In trying to sell the Senate appointment and other similar misconduct while he was governor, Ron was convicted of 18 crimes, including attempted extortion from campaign contributors, corrupt solicitation of funds, wire fraud, that always gets you, good old wire fraud, and lying to federal investigators, another staple of federal prosecutions. As soon as he was arrested in December 2008, Rod also was quickly impeached by the Illinois legislature and removed from office within a month. It sounds like once it was clear that Rod was going down, everyone in Illinois piled on and moved quickly to oust him. Rod's disbarment also happened without much deliberation. The Illinois Supreme Court suspended his law license in 2011 after he was convicted of his 18 federal crimes, and as far as I can tell, there was no written opinion reporting their findings or reasoning, but presumably, being convicted of 18 federal felonies is enough to merit summary disbarment in Illinois, without also having to confirm those crimes involved either the elusive moral turpitude or that they are also felonies under Illinois law, which of course is the right result. An interesting fact about Rod's disbarment: he was the third former Illinois governor to have been disbarred following a criminal conviction, the other two being Otto Kerner and Dan Walker. That's a pretty sad track record for a state that produced both Abraham Lincoln and Barack Obama. Another interesting fact: Ron was not convicted based on his attempt to trade the Senate appointment for a job in President Obama's cabinet, which the court found was not illegal because it was a request that Obama do a public act in return for Rod doing a public act. This is known as a political log roll, and it happens all the time in politics and is not illegal. What is illegal is offering to trade a public act, appointing an interim U.S. senator, for a private act, paying a bribe or its equivalent. In this case, giving Rod a private sector job or giving money to a foundation that Rod would control. In affirming Rod's conviction, Judge Easterbrook of the Seventh Circuit wrote a fascinating opinion explaining the differences between legal political log rolling and illegal attempted extortion, and I commend you to read it. It does, however, make you sick to think about what goes on in our politics and how much of that stuff isn't illegal. But democracy is still better than the alternatives. This point wasn't lost on Judge Easterbrook, who commented as follows, quote, "The prosecutor insists, however, that Blagojevich's situation is different and uncommon because he sought a post in the cabinet for himself. It isn't clear to us that this is unusual. The current Secretary of State, John Kerry, was appointed to that post from a seat in the Senate, and it wouldn't surprise us if this happened at least in part because he had performed a political service for the president, Mr. Obama. Ambassadors, too, come from the House or Senate or from state politics as part of political deals. Some historians say that this is how Earl Warren came to be Chief Justice of the United States. He delivered the California delegation to the 1952 Republican Convention to Eisenhower, rather than Senator Taft, in exchange for a commitment to appoint him to the next vacancy on the Supreme Court. If the prosecutor is right, and a swap of political favors involving a job for one of the politicians is a felony, Then, if the standard account is true, both the President of the United States and the Chief Justice of the United States should have gone to prison." End quote. Judge Easterbrook's opinion in Rod's appeal also chronicles some of the evidence that the feds had against Rod, including audio recordings of Rod that are as colorful as they are incriminating. Turns out that before the whole Senate seat thing came up, Rod already was under investigation by the FBI for similar misconduct. And as part of that ongoing investigation, the FBI had court-authorized wiretaps on Rod's office and cell phones. In one call, Rod says the following about Obama's response to his request to be compensated for the Senate appointment. Quote, "They're not willing to give me anything except appreciation. F them." End quote. Rod ended up serving 8 years of a 14-year prison sentence until his sentence was commuted in 2018 by then-President Donald Trump. To bring things full circle, while Rod was awaiting his second trial and before his conviction, he appeared as a contestant on NBC's The Celebrity Apprentice, hosted by Donald Trump. At the time, Trump praised Rod's, quote, "tremendous courage and guts," end quote, and predicted he would be one of the show's breakout stars. Trump then fired Rod in the 4th episode of the season. The next name on our list is I. Lewis Libby, the 9th most unethical lawyer in U.S. history. Maybe you know him better by his nickname Scooter, as in Scooter Libby, Dick Cheney's chief of staff in the White House of George W. Bush. Scooter got himself in legal and ethical hot water during what became known as the Valerie Plame affair. Scooter was indicted, convicted, and ultimately sentenced to prison for his role in the Valerie Plame affair. And as in many cases, it wasn't the act that nailed poor Scooter, it was the cover-up. According to the allegations at Scooter's trial, shortly after the Iraq War began in 2003, the Bush White House sought to discredit former Ambassador Joseph C. Wilson IV, who was Miss Plame's husband. Why was the Bush White House allegedly upset with Mr. Wilson? The CIA had sent Wilson to the African nation of Niger in 2002 to investigate reports that Iraq had tried to buy nuclear material there for weapons. Mr. Wilson concluded that the report was baseless, and when President Bush and his aides repeated those reports anyway as part of making their case for the invasion of Iraq, Mr. Wilson accused the president of twisting his findings to justify the war to the American people. According to prosecutors, various White House officials, including Scooter, leaked Miss Plame's identity, she was working for the CIA at the time, to the public to suggest that the CIA had chosen Mr. Wilson for the Niger mission because of nepotism in an effort to discredit him, and then tried to cover up the fact that the White House was the source of the leaks. For their part, Mr. Wilson and Miss Plame contend that the disclosure was illegal and put their lives in danger, all for alleged political gain. Much like Al Capone, who was famously sent to jail for tax evasion when he allegedly committed or ordered many murders, Scooter was convicted of crimes related to the cover-up and not the leak itself. Scooter was convicted in March 2007 of 4 counts of obstruction of justice, perjury, and our new favorite, lying to federal investigators. In what became a particularly bad month for Scooter, in June 2007, U.S. District Judge Reggie B. Walton sentenced him to 30 months in prison and denied his motion to remain free on bail pending resolution of his appeal. Scooter appealed Judge Walton's denial of bail pending appeal to the D.C. Circuit, which affirmed Judge Walton's ruling. 1 month later, on July 3, 2007, just hours after the D.C. Circuit rejected his appeal and removed his last legal obstacle to federal prison, President George W. Bush commuted Scooter's prison sentence. President Bush cited Scooter's exceptional public service and lack of criminal record in determining that his 30-month prison sentence was excessive. Liberals decried Mr. Bush's actions, but in fairness to the president, presidential pardons and commutations have been used by presidents of all stripes to dole out personal favors and dispensations, and what Mr. Bush did for Scooter is no worse or better. Unless and until we amend the Constitution to remove this power from the president, it's hard to criticize when particular presidents use the power to pardon in the ad hoc, personal way in which it frankly was intended. And to put a fine point on it, Scooter would have been in real danger in prison, so Mr. Bush probably prevented him from suffering serious harm, which I don't think he deserved. Mr. Bush's commutation of his prison sentence also was in some ways a middle ground and not a full reprieve for Scooter. He didn't pardon Scooter, so his felony convictions stand, which have consequences for his future, as we will see shortly, for his law licenses, and he still required him to pay the $250,000 fine and remain on probation for 2 years that were also parts of his sentence. Of course, avoiding jail time for possibly endangering the lives of Mr. Wilson, Miss Plame, and their families for political gain doesn't feel like justice was served. But what was in essence a political crime, and we saw with President Ford's pardon of Mr. Nixon, can be erased with a presidential pardon and no court can set it aside. As an interesting footnote, as President Bush was leaving office, he issued a flurry of pardons on December 11, 2007, as is the custom of many presidents leaving office, but Scooter was not among the 29 people who received a pardon. So Scooter had to be content with his commuted prison sentence, and I don't think he should complain too much about that. Because President Bush did not pardon Scooter, his 4 felony convictions remain, and after his sentence was commuted and he lost his first appeal in the D.C. Circuit, Scooter decided to drop his appeal of those underlying convictions. As a result, Scooter was disbarred by the District of Columbia Court of Appeals on March 20, 2008. Scooter's disbarment in D.C. wasn't particularly interesting, 4 felony convictions that included perjury and obstruction of justice, as the standard in D.C. basically tracks the one in California. Conviction of a crime involving our old friend moral turpitude requires automatic disbarment, and these crimes involve moral turpitude per se, even if we couldn't define it if our lives depended on it. One interesting fact from the opinion is that Scooter already was under administrative suspension for having failed to pay his bar dues and file the required registration statement. Presumably, he was too busy leaking the identity of covert CIA operative Valerie Plame to fulfill his CLE requirements, pay his dues, and file his annual registration statement. The more interesting part about Scooter's disbarment occurred not in D.C., but in Pennsylvania, where he also had been a member of the bar. In December 2008, the Pennsylvania Supreme Court disbarred Scooter in an act of reciprocal discipline, pursuant to Pennsylvania Rule of Discipline 216, upon receiving notice of the D.C. Court of Appeals disbarment order. Reciprocal discipline is an interesting topic, and one that doesn't come up very often, as most lawyers are admitted in only one state, and one I thought we would spend some time discussing. At least it is interesting to me as someone who is admitted in 2 states, California and New York. I'd like to think that if I ever were unfortunate enough to be disbarred in one state, I could still practice law in the other. Sadly, reciprocal discipline statutes generally preclude that result, except in rare cases where ordering the reciprocal disbarment of a lawyer would result in grave injustice, which is the standard in Pennsylvania under Rule 216. Not surprisingly, Scooter's reciprocal disbarment in Pennsylvania would not have resulted in grave injustice. Indeed, most people think he was insufficiently punished for his crimes in light of President Bush's commutation of his prison sentence, and he was summarily disbarred in December 2008. There is, however, an interesting case that the Pennsylvania Supreme Court decided in 2001, where they found that reciprocal disbarment of a lawyer would have resulted in grave injustice, and that is worth discussing in some detail because it sets out the standard that many other states following when imposing reciprocal discipline on lawyers. Dennis J. Aiullo was admitted to practice law in New Jersey in 1972. He started his career as a solo practitioner, undertaking all tasks of running a law office, including typing, filing, and bookkeeping, which is the primary reason he got into trouble. Apparently, times were lean for Dennis, and he supplemented his income by running a typing service for other lawyers. This was the 1970s when everything had to be typed by someone, not word processed. That allowed him to support himself and his family. To Dennis's credit, he also found the time to do significant pro bono work, particularly on behalf of the homeless in New Jersey, and he was active in his church where he participated in religious education for children and assistance to senior citizens. Dennis certainly seems like a nice guy, so what got him into hot water with the New Jersey bar? The answer is the same thing that gets most lawyers who get disbarred into trouble. Most lawyers get disbarred because they misused and/or commingled client funds, and that is what happened to young Dennis. It turns out that when times were tough, Dennis used some funds belonging to one client to pay the expenses relating to another client, in violation of a lawyer's duty to hold funds in trust only for the benefit of the client to whom the funds belong. There was no claim that Dennis used his client's funds to pay his own bills or for any other improper purpose, but he knowingly commingled them in violation of his ethical obligations. So, for all you young lawyers out there, please pay close attention to this. At some point in your career, you are likely to come into possession of some money entrusted to you by a client. Perhaps it's a retainer or an advance given to pay for costs or funds to pay a settlement or judgment. When you receive that money, you must never forget that it is being entrusted to you as a fiduciary and a lawyer, and how you handle that money is critically important to maintaining your law license. If you look at the disciplinary reports in your state about the lawyers who have been disbarred, the vast majority lose their law licenses because they mishandled client funds. Period. Full stop. You generally don't get disbarred for the hard stuff, making a tough decision to reveal a client's secret when required to prevent death or serious bodily harm in states that allow that, for example. You get disbarred for the easy stuff, the requirement to keep client funds in trust and not commingle them. So just don't do it, and you'll likely be able to keep that law license you worked so hard to acquire. But alas, that is what happened to poor Dennis, who, as we have learned, is otherwise a pretty good guy. So, after Dennis pled guilty to 2 counts of knowing misapplication of client funds, he was permanently disbarred in New Jersey in 1989. Like many states, disbarment in New Jersey is permanent. There is no realistic chance that you can be rebarred after having been disbarred. Indeed, reinstatement of a disbarred lawyer has happened in New Jersey only 3 times in the past 100 years. Not good odds for poor Dennis. So he did what any smart lawyer would do in the circumstances. He walked across the border to Pennsylvania and sought permission to take the Pennsylvania bar exam. It took Dennis a couple of tries to get permission to sit for the Pennsylvania bar. Obviously, he had to disclose his disbarment in New Jersey and had to convince the Pennsylvania Board of Law Examiners that he was morally fit to practice law in Pennsylvania despite his disbarment, which he ultimately did. And when he did, he passed the bar and was admitted in Pennsylvania in July 1999. But guess who was not yet on board with this plan? The Supreme Court of Pennsylvania, which in December 1999 sent Dennis an order to show cause why he should not be subject to reciprocal disbarment in Pennsylvania due to his disbarment in New Jersey. Dennis appeared before the court and made his case, which the court ultimately accepted and allowed him to maintain his law license in Pennsylvania. The standard the court applied is set out in Rule 216, and it provides that if a lawyer has been disciplined in another state, Pennsylvania shall apply reciprocal discipline in Pennsylvania unless the lawyer can show 1. The other state's procedure was so lacking in notice or opportunity to be heard as to constitute a deprivation of due process. 2. There was such an infirmity of proof establishing the misconduct as to give rise to the clear conviction that the court could not accept that state's conclusion on the subject. 3. That the misconduct established has been held to warrant substantially different discipline in Pennsylvania. Or 4. Imposition of the same or comparable discipline would result in grave injustice. For Dennis, his only argument was that disbarring him in Pennsylvania would work a grave injustice. So that is what he argued, and that is what the court accepted, which seems like the right result, if for no other reason than to allow a lawyer to take your state's bar exam after he disclosed his prior disbarment, only to disbar him less than 6 months later because he had been disbarred, seems just plain cruel and pretty darn unusual punishment. In Pennsylvania's defense, it subsequently amended its rules to prevent any disbarred lawyer from taking the Pennsylvania bar exam. But that rule change was made after Dennis had been allowed to take the Pennsylvania bar, obviously, as a result of Dennis's case. So, if you are ever disbarred in one state, your chances of keeping your license in another state where you are admitted are pretty slim, and they rest on the 4 factors outlined above. Why is the bar so high to avoiding reciprocal discipline, including reciprocal disbarment? As the Pennsylvania Supreme Court explained, they examine the legitimate goals of the originating and reciprocal states' disciplinary systems. the need to protect the public and the integrity of the judicial system, and the desire to deter lawyers from engaging in misconduct. Setting aside the legal framework for a moment, what reciprocal discipline is all about is that no state wants to become the dumping ground for another state's disbarred lawyers. If the worst and least ethical lawyers in New Jersey can simply walk across the border and set up shop in Pennsylvania, that's a terrible result for Pennsylvania's courts, lawyers, and clients. That's exactly why Pennsylvania changed its rules to prevent any lawyer who has been disbarred or suspended for disciplinary reasons in another state from sitting for the Pennsylvania bar exam. If you can't take the bar, you can't practice law in Pennsylvania, which effectively shuts the door on most disbarred lawyers. In conclusion, unless there is something really questionable about your disbarment in your home state, such as a lack of due process or evidence, or if your misconduct would be punished very differently in another state, you're highly unlikely to avoid reciprocal disbarment in any other states where you are admitted, unless, of course, you can show grave injustice, which is going to be very, very difficult to show, as Dennis's case being that rare exception that aptly proves the rule. Coming in at number 8 is William Jefferson Clinton, the 42nd President of the United States. What did Bill Clinton do that got himself impeached and nearly removed from the presidency, and of much, much less significance to the world, but of much, much more significance to us, ultimately suspended from the practice of law? It all started in 1994 when Paula Jones, a former Arkansas state employee, sued Bill Clinton for alleged actions that began in 1991 in a hotel suite in Little Rock when Clinton was governor of Arkansas. Jones alleged that an Arkansas state trooper persuaded her to leave the registration desk she was staffing and visit Governor Clinton in a business suite at the hotel. Jones claimed the governor made boorish and offensive sexual advances that she rejected, and that her superiors at work subsequently dealt with her in a hostile and rude manner and punished her in a tangible way for rejecting those advances. It's hard to believe even today that this simple lawsuit alleging sexual harassment, which ultimately was dismissed by the court on summary judgment, led to the impeachment and near removal of the President of the United States. But, as in many things in politics and in life, it's not the act that gets you in trouble, but rather, it's the cover-up. As you might expect, President Bill Clinton was none too excited to be hit with this lawsuit during just his second year in the White House. Indeed, like Troopergate, Travelgate, and Filegate, Clinton regarded the Paula Jones case as a politically inspired lawsuit that he was determined to fight with every fiber of his being, and more effectively, with an army of high-powered lawyers from Williams and Connolly and Skadden. Their first tactic was to argue that a sitting president is immune from civil lawsuits while he is in office, an argument that President Clinton took all the way to the U.S. Supreme Court, which ultimately rejected it, ruling in a case of first impression that a civil case against a president based upon unofficial conduct occurring before he took office could proceed against him while he is in office, including both discovery and trial proceedings if necessary. That loss in the Supreme Court would turn out to be critical because it was how President Clinton answered questions under oath in the discovery process in the Paula Jones case and in grand jury testimony commissioned by independent counsel Kenneth Starr that provided the basis for Clinton's impeachment in Congress and the suspension of his law license. Once the Supreme Court cleared the way, the Paula Jones civil case started moving forward in the Eastern District of Arkansas before the Honorable Susan Weber Wright. The Jones case was groundbreaking in almost every possible way, including requiring a sitting president to respond to discovery requests and to sit for a civil deposition, which took place on January 17, 1998. Because of the highly contentious nature of the litigation, some 50 discovery motions had been filed and some 30 discovery orders issued in total, and the unique position of the defendant as the most powerful man in the free world, Judge Wright agreed to travel to Washington, D.C. to preside in person over President Clinton's deposition. On that fateful occasion, President Clinton was questioned extensively about whether he had had a sexual relationship with a former White House intern named Monica Lewinsky. Over the objections of Bob Bennett, President Clinton's lawyer from Skadden, President Clinton testified under oath that he had no recollection of ever having been alone with Miss Lewinsky, and he denied that he had engaged in an extramarital affair, in sexual relations, or in a sexual relationship with Miss Lewinsky. Judge Weber allowed this line of questioning, reasoning that Paula Jones was entitled to discover information regarding any individuals with whom the president had had sexual relations or proposed or sought to have sexual relations, and who were state or federal employees from 1991 to the present, which seems reasonable given the nature of the allegations in her complaint. In addition to having been questioned directly about a sexual relationship with Ms. Lewinsky, and in a clear misstep given the truth that came out later, Mr. Bennett asked President Clinton during his deposition whether an affidavit submitted by Ms. Lewinsky in which she denied having had sexual relations with him was a true and accurate statement, to which President Clinton responded, quote, "That is absolutely true," end quote. Okay, so for anyone who was too young at the time to remember Monica Gate, which sadly might be a good many of you at this point, President Clinton did have sexual relations with that woman, Ms. Lewinsky, in a major way. While they did not have sexual intercourse, they did pretty much everything else. Oral sex performed on President Clinton by Ms. Lewinsky, penetration of Ms. Lewinsky by President Clinton's fingers, and oddly by a cigar, most of which took place when the two of them were alone in a room just off the Oval Office. The salacious details of their encounters can be found with a simple Google search. There was a soiled blue Gap dress, a famous black beret, and secret recordings of Ms. Lewinsky confiding to her friend Linda Tripp about her relationship with President Clinton that her friend subsequently turned over to Republican operatives, so I won't spend time relating them here. Suffice it to say that President Clinton's unequivocal denials under oath of a sexual relationship with Ms. Lewinsky were knowingly false at the time he made them. Much more famous than President Clinton's deposition testimony was his testimony before a federal grand jury, where he was questioned by prosecutors working for independent counsel Ken Starr about Ms. Lewinsky. Here is how that now famous exchange went. Question. Quote, "Mr. President, I want to, before I go into a new subject area, briefly go over something you were talking about with Mr. Bittman, the statement of your attorney, Mr. Bennett, at the Paula Jones deposition. Counsel is fully aware that Ms. Lewinsky has an affidavit which they are in possession of, saying that there is absolutely no sex of any kind in any manner, shape, or form with President Clinton. That statement was made by your attorney in front of Judge Susan Weber Wright, correct? Answer, that's correct. Question, that statement is a completely false statement. Whether or not Mr. Bennett knew of your relationship with Ms. Lewinsky, the statement that there was no sex of any kind in any manner, shape, or form with President Clinton was an utterly false statement. Is that correct? Answer, it depends on what the definition of is. If is means is and never has been, that is not, that is one thing. If it means there is none, that was a completely true statement. Okay, so one word of advice for pretty much everyone. The answer to a question is never, it depends on what the definition of is. President Clinton, is today Tuesday? It depends on what the definition of is. No, it doesn't. Today is either a Tuesday or it's not. But President Clinton wasn't done yet. He also testified under oath in the grand jury in response to other questions about whether he was ever alone with Ms. Lewinsky. Quote, it depends on how you define alone, and there were a lot of times when we were alone, but I never really thought we were. End quote. Come on, Mr. President, you were alone with Ms. Lewinsky when you were in a room and she was in that same room and no one else was in that same room. It does not depend on the definition of alone or even whether it was a Tuesday. By giving such ridiculous testimony to a federal grand jury under oath, while at the same time serving as the nation's chief law enforcement officer, I think President Clinton pretty much confirmed most people's already low opinion of politicians and lawyers. Of particular interest to us as lawyers, President Clinton also offered up a lame excuse for his prior deposition testimony when he subsequently told the grand jury, quote, but as I have testified and I would like to testify again today, it is somewhat unusual for a client to be asked about his lawyer's statements, instead of the other way around. I was not paying a great deal of attention to this exchange. I was focusing on my own testimony. And I am not sure, Mr. Weisberg, as I sit here today, that I sat there and I followed all those interchanges between the lawyers. I'm quite sure that I didn't follow all those interchanges between the lawyers all that carefully. And I don't really believe, therefore, that I can say Mr. Bennett's testimony or statement is testimony and is imputable to me. I don't know that I was even paying that much attention to it, end quote. It strains credulity for President Clinton to claim that he wasn't paying attention when his lawyer represented during his deposition, presided over by a federal judge, that Ms. Lewinsky had, quote, no sex of any kind in any manner, shape, or form, end quote, with him. Obviously, President Clinton was happy to have Mr. Bennett make this argument on his behalf in the hope it was going to put the Lewinsky issue to bed, and clearly Mr. Bennett did not know the truth when he made these statements to the court. It's an interesting ethical question whether a client, who happens to be a lawyer but who is not representing himself in his own case, commits an ethical violation if he allows his lawyer to make statements to the court that the client knows are false. I think the answer is probably yes, and it definitely should be yes, but that's not one of the bases on which Mr. President Clinton was disciplined by the Arkansas State Bar. Arkansas follows the ABA Model Rules, and Model Rule 8.4 states that, quote, it is professional misconduct for a lawyer to A, violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another, and then skipping down to C, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, D, engage in conduct that is prejudicial to the administration of justice, end quote. I think there's a strong case to be made that President Clinton violated each of these parts of Rule 8.4 when he knowingly allowed his lawyer to make false statements to the court. I suppose you could argue that lawyers, when they are acting as clients and not lawyers, should not be required to correct false statements made by their lawyer, but I think that argument clearly is wrong. Had Judge Weber accepted Mr. Bennett's false statements and issued a ruling in reliance on them by, for example, quashing the subpoena that had been issued to Ms. Lewinsky, President Clinton's conduct clearly would have prejudiced the administration of justice in violation of Rule 8.4d. I think he also violated Rule 8.4a by inducing Mr. Bennett to violate the rules of professional conduct, although because Mr. Bennett did not know his statements were false, he did not in fact violate the ethics rules, which prohibit only knowingly false statements made by a lawyer representing a client, and also Rule 8.4c by engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. I don't think you could say President Clinton violated Arkansas Rule 4.1, which prohibits lawyers from making knowingly false statements of material fact or law to a third person, which is the rule I was just referring to, both because President Clinton did not make the statement in question, Mr. Bennett did, and because Rule 4.1 requires that the lawyer make the false statement in the course of representing a client, which President Clinton was not doing either. Even if President Clinton clearly adopted the false statement, which he did not clearly do, he just remained silent, he still would not have been doing any of this in the course of representing a client. That said, as a lawyer, I think you are skating on thin ice if you allow your lawyer to make statements on your behalf that you know are false to a court, and it isn't going to save you from a Rule 8.4 violation to claim that you weren't paying that much attention or that those statements wouldn't be imputed to you. We'll get to what disciplinary rules the Arkansas State Bar found that President Clinton violated a bit later. But for now, let's finish up the main story of President Clinton's impeachment and near removal from office. Of course, the main upshot of President Clinton's false statements under oath denying his extramarital affair with Ms. Lewinsky and his efforts to cover up that affair was that Ken Starr presented 4 charges of impeachment to the House of Representatives in December 1998: perjury to a grand jury, obstruction of justice, a second count of perjury in the Jones case, and abuse of power. The Republican-controlled House, voting mostly along party lines, impeached President Clinton on December 19, 1998, on the charges of perjury to a grand jury and obstruction of justice. The other 2 charges failed to pass by a majority vote. As an interesting aside, during the impeachment process, at least 3 prominent Republican members of Congress were outed as having had their own extramarital affairs, which caused many to levy charges of hypocrisy against the Republicans who were seeking to remove President Clinton for similar conduct, albeit without the lying under oath or obstruction of justice parts. As a result of the House vote, President Clinton became only the second president to be impeached. The first was not Richard Nixon, who resigned before he could be impeached, and you'll hear more about him later, but was President Andrew Johnson, who was impeached but not removed from office in 1868. In case you're curious, President Johnson was impeached as political payback from radical Republicans who sought to punish him for granting amnesty to ex-Confederates and enacting a program that allowed rapid restoration of U.S. state status for the seceded states. All of this despite the fact that President Johnson had been the only U.S. senator from a seceding U.S. state to remain loyal to the Union before the Civil War broke out. While President Johnson suffered what most now regard as a noble impeachment, it's hard to call President Clinton's anything but ignoble. I'm sure each of you has had an opinion about the last two impeachments of President Trump, so I'll say no more about that. Once President Clinton was impeached, he faced trial in the Senate where a 2/3 majority vote was required to remove him from office. The Senate trial began on January 7, 1999, was presided over by Chief Justice William Rehnquist, and was quite a spectacle. 13 House Republicans served as managers, aka the prosecutors, who presented the charges and evidence against President Clinton over 3 days, followed by 3 days of argument and evidence by President Clinton's defense team. In essence, the prosecutors charged President Clinton with willful, premeditated, deliberate corruption of the nation's system of justice through perjury and obstruction of justice. In his defense, Clinton's lawyers made 3 main arguments. Number 1, his grand jury testimony had too many inconsistencies to be a clear case of perjury. Number 2, the investigation and impeachment was tainted by partisan political bias. And 3, with more than a 70% approval rating, his ability to govern clearly had not been affected by the scandal. Speaking for the president, White House counsel Charles Ruff summed it up in his closing argument as follows, quote, "There is only one question before you, albeit a difficult one that is a question of fact and law and constitutional theory. Would it put at risk the liberties of the people to retain the president in office? Putting aside partisan animus, if you can honestly say that it would not, that those liberties are safe in his hands, then you must vote to acquit," end quote. Chief Prosecutor Senator Henry Hyde countered, quote, "A failure to convict will make the statement that lying under oath, while unpleasant and to be avoided, is not all that serious. We have reduced lying under oath to a breach of etiquette, but only if you are president. And now let us take our place in history on the side of honor, and oh yes, let right be done," end quote. The final vote was 45 guilty and 55 not guilty on the perjury charge, and 50 guilty and 50 not guilty on the obstruction of justice charge, which meant that both charges failed and President Clinton was not removed from office. With the benefit of hindsight and 20 years of subsequent history, I would make the argument that the result in President Clinton's impeachment was exactly the right one, even if we got there by accident. President Clinton clearly committed perjury and obstructed justice, and for that, he became only the second president in history to be impeached, which leaves a black mark on his presidency that I am sure he would give anything to remove if he could. This upholds the rule of law and the principle that no one, not even the President of the United States, is above the law, and that lying under oath and obstructing justice are wrong and must be punished. For the Democrats who voted to acquit President Clinton, they were punished when in 2000 Al Gore was defeated by George W. Bush after an exceedingly close election that was decided by Florida and the Supreme Court that many people believe was only made so close by a desire to restore dignity to the White House after President Clinton and his many scandals. One newspaper reported that exit polls showed that in the era of the Clinton-era scandals, the single most significant reason people voted for Bush was his moral character. Even Monica Lewinsky was punished for having gotten involved with a married man, although given the harsh treatment she suffered in the press, her punishment in the form of almost unprecedented public shaming hardly seems to have fit her crime. On the bright side, Ms. Lewinsky has been a vocal anti-bullying advocate who has managed to move on from the scandal some 25 years later. At the same time, there could be no doubt that President Clinton was the target of a partisan witch hunt that first nurtured the Paula Jones case, and once the ball got rolling, picked up momentum and willing followers such as Linda Tripp, Kenneth Starr, and House Republicans, who sought nothing more than the removal of a popular Democratic president. While perjury and obstruction of justice are wrong, President Clinton's conduct in a private civil lawsuit did not impair his ability to serve as president, and there was no basis to remove him from office for such conduct. When presidents of other countries are removed from office, it is typically for graft, nepotism, misleading the public on matters of public concern, etc., and President Clinton was guilty of none of those offenses. Although President Clinton escaped removal from office, he could not escape the wrath of Judge Susan Weber Wright or sanctions from the Arkansas State Bar. Once the facts about President Clinton's improper sexual relationship with Ms. Lewinsky came out during his impeachment, Judge Weber Wright found President Clinton in civil contempt of court for having responded to plaintiffs' questions by giving false, misleading, and evasive answers that were designed to obstruct the judicial process. Judge Weber Wright cited not only President Clinton's deposition testimony, but also his response to plaintiff's interrogatory number 10, where he answered none in response to an interrogatory asking him to name each and every federal employee with whom he'd had sexual relations when he was President of the United States. Here's Judge Weber Wright in her own words, quote, "The President's contumacious conduct in this case, coming as it did from a member of the bar and chief law enforcement officer of the nation, was without justification and undermined the integrity of the judicial system. Sanctions must be imposed, not only to redress the misconduct of the President in this case, but to deter others who, having observed the President's televised address to the nation in which his defiance of this court's discovery orders was revealed, might themselves consider emulating the President of the United States by willfully violating discovery orders of this and other courts, thereby engaging in conduct that undermines the integrity of the judicial system." Ouch. I commend you to read the rest of Judge Weber Wright's opinion, as it is a pretty thorough dressing down of the most powerful man in the free world, and I think she uses the word contumacious at least 6 times. Contumacious means stubbornly disobedient or rebellious, in case you didn't learn that word for the SAT. Although Judge Weber Wright stated in her opinion that she takes, quote, "no pleasure whatsoever in holding this nation's president in contempt of court," end quote, it's clear she was pretty upset that the president didn't respect her or her discovery orders, particularly after she accorded him such respect by agreeing to preside over his deposition in Washington, D.C. After also finding that she had the authority as a federal district judge to hold the President of the United States in civil contempt based upon his conduct as a civil litigant, she found him in civil contempt pursuant to Federal Rule of Civil Procedure 37b2. After finding President Clinton in civil contempt, Judge Weber Wright imposed the following sanctions. First, she ordered the president to pay the legal fees of the plaintiff's lawyers caused by his willful failure to follow the court's discovery orders. Second, she ordered the president to reimburse the court for its expenses in traveling to Washington, D.C. to preside over his deposition. And third, she referred this matter to the Arkansas State Bar for possible disciplinary action, specifically citing Rule 8.4's prohibition against engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, or prejudicial to the administration of justice. In yet another odd twist in this case, despite the referral from Judge Weber Wright, the Arkansas State Bar didn't decide to hold a hearing on President Clinton's conduct until after the Southeastern Legal Foundation, a conservative legal group, filed its own complaint against President Clinton alleging the same misconduct. And that group actually had to win an order from the Arkansas Supreme Court mandating that the disciplinary process go forward. Once the Arkansas State Bar was forced to take up the issue, the resolution happened pretty swiftly, with President Clinton agreeing to a 3-way deal with the State Bar, Paula Jones's lawyers, and Robert Ray, the independent counsel who took over the investigation from Ken Starr. Under the deal, President Clinton admitted that he had some answers he gave in his civil deposition were false, and that he knowingly gave misleading and evasive answers, although he maintained that he did not intend to lie. In consideration of this admission, the State Bar found that President Clinton violated Rule 8.4d, suspended him for 5 years from the practice of law effective January 19, 2001, and ordered him to pay a $25,000 fine. The deal also involved a settlement for Paula Jones in the civil lawsuit, which in the meantime had been dismissed on summary judgment but was still pending appeal, in the amount of $850,000, plus about $90,000 in attorney's fees. In addition to Arkansas, President Clinton also had been admitted to the bar of the Supreme Court of the United States, and after that court suspended him pending an order to show cause why he should not be disbarred in that court, President Clinton resigned instead. Thus ends forever the legal career of William Jefferson Clinton, or does it? As noted, Arkansas suspended President Clinton from the practice of law but did not disbar him, and his 5-year suspension expired in January 2006. Bill Clinton is now eligible for reinstatement to the practice of law, so will he apply for reinstatement? He hasn't so far, even though officials in Arkansas have been preparing for his application since he first became eligible a little over 10 years ago. According to an Arkansas bar official, in most cases, the presumption is that unless some good cause can be shown, a suspended lawyer will be reinstated to the bar upon such application. Of course, Bill Clinton's situation is the polar opposite of most cases. For his part, Clinton seems to have little interest in returning to the practice of law, as he now makes a fat living giving speeches at $100,000 or $300,000 each. And with that, we've reached the end of part 1 of the Dirty Dozen, the 12 most unethical lawyers in the history of the United States. I hope you enjoyed it, and thanks for watching.